So good morning, ladies and gentlemen from sunny Alicante, and welcome to this second panel of the third session of our conference today. The theme of our panel is, the focus will be on the scope of protection of geographical indications and more particularly on case law developments in this very interesting area of law. My name is Dimitris Botis. I'm the Deputy Director in charge of Legal Affairs at the European Union Intellectual Property Office. And I have the pleasure of being the moderator of this panel. And I'm also delighted to welcome our eminent keynote speakers who will set the scene for our discussion today. Our three speakers is first Judge Marko Ilešič from the European Court of Justice, who has dealt with a plethora of intriguing IP cases during his distinguished career. Second, Mr. Benjamin Fontaine, current chair of the European Community Trademark Association's EUIPO-Link committee and former chair of ECTA's GI committee and a declared GI enthusiast. And third, we have with us Dr. Dev Gangjee, a professor of IP law at the University of Oxford, who will add an academic touch to our debate, I think in continuation of the line that he started today at his keynote speech. So gentlemen, thank you very much again for accepting our invitation. It is a singular honor to have you today with us. I also understand that we have more than 330 participants registered. At this moment, I see that we have 126 connected and counting, which alone shows the relevance of this subject both for the agricultural sector and for legal practitioners and regulators. So thank you very much for honoring us with your presence. And remember to send us your questions through the Q&A facility in the tool. You can also raise your hand when I open the Q&A session after the speeches if you want to take the floor in person. I will see that and I will give you the floor. So ladies and gentlemen, in recent years, we see more and more preliminary references being addressed to the Court of Justice with the purpose of clarifying the conditions and scope of protection of geographical indications. Already, the Court has made a substantial contribution to the interpretation of the relevant provisions, in particular as regards the elucidation of concepts such as use, evocation, and exploitation, etc. However, there are quite a few points in the law whose exact meaning and place in the assessment remains unclear. So what about the role of the goods? What about use in relation to services? What about use of the GI as an ingredient? And what is the true nature of the reputation of the GI? Is it the same as in trademark law or is it different? For instance, what is a misuse and what kind of practices does it extend to? And finally, what about the protection of GIs as collective marks? These are all valid questions that we will try to address as comprehensively as possible today. And my plan was to invite first Judge Ilešič to speak, because it's fitting, I think, to start our discussion by giving the floor to the Court of Justice. However, I see that we have some technical issues. Judge Ilešič will be with us in a second, I hope. So I will start by giving the floor to Benjamin Fontaine, to our, who was listed as our second speaker, who will focus more on questions that have to do with the systematic treatment of the goods and services in the area of protection of GIs. So without further ado, I will pass the floor to Benjamin, reminding him that he has 10 minutes to develop his subject. So Benjamin, the floor is yours. Thank you very much.
Thanks a lot, Dimitris. And thanks to everyone for attending this interesting session. We will go, if you allow me, from sunny Alicante, as Dimitris said, to the more cloudy Scotland. If I may start my presentation by telling you a story. I went to Scotland some time ago before the lockdown, because I love that country. And I went far east to visit a place called Port Charlotte. I went there because I thought this was the place where they made this wonderful port wine. But I did not find any in this very nice village. However, I found a pub, very nice old pub from Scotland, which however had a very strange name. It was called Champanillo. But I thought, okay, maybe I could get in and see what's in this Champanillo. Maybe I will get a lot of champagne wine and high premium products, etc. So I went there to the Champagne pub, and I was quite surprised because in there it was a typical Scottish pub, but nothing of champagne wines, etc. Anyway, I stayed there because it was a nice place, and I had a drink, and I wanted to choose a very good Scotch whiskey. And how do I do that? There were plenty of offers. It was full of bottles, old bottles of Scotch whiskies. And as I'm not a specialist, I chose by name, and I chose a typical Scottish name. I took a bottle of Glen Buchenbach, which I took with me, which was there displayed. And also I was hungry, so I said, I'm gonna have lunch in this pub, and I had a very good, typical, authentic basmati rice from Pakistan. And also I had some Morbier cheese. I think it was Morbier, I'm not sure, but it had the typical black line in the middle. And for me, it was Morbier, and I enjoyed my lunch at the pub. And then I left back to my hotel. And while I was walking, eating a very good champagne sorbet, which I had just purchased at a Lidl. And I should say that sorbet was extremely good. You could taste it was real champagne in it. I was thinking, well, it's funny because this visit I've made to Port Charlotte shows me that our daily life is full of these names that bring us to authenticity, to our history, to the products we like, to our culture. And I thought, well, how are these names protected in the EU? I'd like to know a bit more about this. And as I'm a lawyer, I went to see and I looked for an EU regulation on GIs. And surprisingly, there was no EU regulation on GIs. There were 4 of them. Very surprising. So I chose to review one. I'm trying to skip my presentation. Yes. And I reviewed the specifications in this wine GI regulation, and I tried to understand how the GIs were protected. And as I am called here to talk about the goods and services more particularly, I have highlighted the scope here in this extract of the wine regulation. We know a few things by now, thanks to the Code of Justice. We know that, for example, we have a protection which is clear for comparable products. And the Code of Justice has told us that comparable products are products with common objective characteristics. They have the same nature, the same distribution channels, they are consumed on the same occasions. We know also by the law that we can have an extra layer of protection if the infringing product exploits the reputation of the GI. But we have a difficulty in the next aspect of the law, which is the point B here, which contains the evocation, refers to the evocation. Evocation is the main point in GI protection. This is the main issue. And the problem we have is this article B, which talks about evocation, doesn't tell us for which goods or services this evocation applies. Is it only for comparable goods or for anything? The only thing we can see here is that the protection can be granted even if the true origin of a good or a service is indicated. So I thought, well, I don't understand very well the law, so I'm going to check the case law, okay? So I went to see the case law, and I went to see the case law of the Boards of Appeal of the EUIPO. And I was lucky, I found very recent decisions of the Boards of Appeal. However, these Boards of Appeal took a different approach in decisions which I issued very closely earlier this year. In Port Rüge, the Board of Appeal said point B on evocation would not apply beyond comparable goods today in accordance with the case law. Well, on the contrary, another Board of Appeal in the Champagne case said, no. Point B evocation has no limit on scope. It can apply even to non-comparable goods or services if, of course, there is harm done or an undue profit to the reputation of the GI. So I said, oh my God, I don't know what is the practice of the EUIPO. I should look further. And I went to the Court of Justice. And this is, of course, the top jurisdiction. There is nothing beyond. And luckily, we have a case which is pending before the Court of Justice. It's a reference by a Spanish court in Barcelona on a case that involves the champagne producers against a few tapas bar called Champanillo. They are originally, these people were also producing a sparkling wine. I have added a picture here. You can see from the color of the wine that it was a very scary product. They have ceased the use of this bubbling wine, but still they are using Champanillo for the tapas bar. And the Court of Barcelona has referred a number of questions to the Court of Justice. The questions maybe are not very, very well drafted, but if we try to wrap up the question, the Court of Justice needs to provide indications to the judge on how you implement the evocation in practice. Is there some sort of interdependence of all the factors? You put them together and you evaluate whether there is a difficulty or not? Or is it more a mechanical approach? First, the goods and services should be comparable, and then we will see whether there is an evocation, if the signs are sufficiently similar, etc. And I think it is a very interesting point, and I think the answer basically that the Court of Justice could bring to this should be very generous, very wide, in the sense that we should not apply point B in a artificial mechanical manner. We should wrap up all the elements together, make a global assessment, and see whether there is an infringement of the GI. And in this global assessment, a number of factors should be taken into account. The degree of proximity between the signs, okay, the reputation of the GI in the meaning, of course, of GI law, not reputation of trademark law. The nature and the degree of similarity of the goods and services also plays a role. The more close they will be, the easier you will get an infringement. We should make this assessment by taking into account the public of all the EU, that is very important. And we should also take into account the intention of the alleged infringer, because we know also that this plays a role, although it is a subjective element. I think that if we agree to apply point B in this wide manner, we will get better results. One example is a missed opportunity by the Spanish courts in the Champagne case, where infringement of champagne was denied. And for me, it was a very, very unfortunate decision. Champagne is not a direct use of champagne. It falls in B, in my view. It's an imitation of champagne or an evocation. However, it does not apply in this case to goods which are comparable to champagne. Of course, this is a non-alcoholic beverage, okay? And clearly, however, this beverage was taking unfair advantage of champagne. And unfortunately, this was not recognized by the Spanish courts. So, and I will finish here, and I will finish on time, Dimitris. I have played a little bit, because the purpose of this conference is to think of the future. I have elaborated an alternative proposal of the wording of what I would call the future single GI regulation. I know it's not the intention of the Commission, but I believe that it is not the right thing. We should have a single GI regulation in the EU. And I have, in this proposal, included a wide provision at point B, which would apply for comparable but also non-comparable goods, provided, and that is the key of the assessment, that in the end, it's not the goods that matter. In the end, is whether we harm the specific function of the protected names, okay? And also whether we take a fair advantage or dilute the reputation of the protected name. And this is a way of thinking. And for those of you who would want to make a comparison with other provisions, I think that if you look at the Geneva Act of the Lisbon Agreement, we have something which is quite similar to that. which I believe is the right approach. And by the way, we are now members of this agreement, and we will have to make sure that our law is compatible with the provisions of the Geneva Act. Okay, and with this, I thank you for your attention and stay safe.
Thank you, Benjamin. I think you forgot to tell us about your last slide. Use on COVID masks of champagne is a prohibited use, or?
No, this is fine. This is no problem, not commercial.
Okay, so that's, let's say, advertising function. Thank you very much, Benjamin. Thank you very much. And you actually went the extra mile. That was precisely the spirit of our panel today. See how clear is the law, and if we believe that it could be improved in certain areas, perhaps also imagine of possible solutions. So you have done both. Thank you very much. I understand that your conclusion regarding the goods, both under the current text through an interpretation, but also as a possible formulation of the law in the future, you take the position that we do not need a formal reference to the products in the regulation, because, let's say, naturally, the distance between the goods will come into play when we assess evocation. So we know this also happens in trademarks. For some goods, it's easier to create a mental associations, for some others not. So very fair position. Thank you very much, Benjamin. I see that still Judge Ilešič is not with us. I hope that he can make it in time. So I will now give the floor to Dev Gangjee and ask him the same question, but from a slightly different perspective. So Dev, good morning. Thank you for joining us, first of all. Then the question that I would ask you is, we know that GIs are also often protected as collective trademarks, or there's an effort to find other intellectual property rights for which the same terms could be protected. For you, is the landscape clear in EU law? I mean, how easy is it? Is it a challenge? Is it a safe haven for producers to also think about extra layers of protection coming from other intellectual property rights?
So that's a great question. I'm happy to answer it. I have a few slides to answer it as well. I think the short answer is the ground is changing, and the ground is changing sort of in an unexpected way. And I think it's making life more challenging for GI rights holders to assert their rights within the trademark system for reasons I'm not still clear about. So it would be good to share that with the audience and see what people have to say. So I'm happy to sort of commence with the presentation now. Is it possible to have the slides uploaded? I could use this time to do something I've been meaning to do, which is to thank my co-panelists. For some years now, I've benefited from sharing ideas and just learning from Benjamin and from Dimitris, so it's a chance to say thank you. And I'm also a reader of the Fifth Chamber's judgments, so I would have said thank you in person to the judge as well. So this is a good community to be a part of and to learn from, even when we're not aligned on the same side. It's always a productive discussion. I'm wondering if it would be easier for me just to share my screen, because I have my slides here, so we could try doing it that way as well.
OK. Et maintenant? Maintenant, tout est OK?
Oui, je vois que quelqu'un là.
En fait, il y avait tout ce qui était affiché sur l'écran. Il fallait choisir Join from browser et Join from audio computer.
C'est bon, merci.
Vous êtes là, il faut juste que je redonne.
Oui, merci beaucoup.
Bonne journée.
Au revoir.
Hello.
Hello, I see we have Judge Ilešič with us. Good morning, or rather good afternoon. It's very good to have you with us.
Okay, I'm sorry.
No problem. We just let Mr. Fontaine speak first. We wanted to keep for you the place of honor, but there were some technical...
I can be the last one. Okay, I don't mind.
No, there is no problem. We can perhaps now give the floor to Judge Marko Ilešič that I presented in my... Yes, please.
Can you hear me?
Yes, we can hear you very well. We can see you. All is perfect. And I'm very sorry for the technical complications. So we were just discussing the clarity of the law when it comes to stating the scope of protection of GIs and how easy it is to apply. We also referred to the big effort the Court of Justice has done to clarify concepts like evocation, use, undue exploitation of reputation. And we thought that it would be a very good idea to ask you, ask your views about the state of the case law and the complexities a judge is faced with when called to interpret the admittedly complex legal framework that governs the scope of protection of geographical indications. So we would very much appreciate receiving your views on this point in the next 10 minutes.
Oh, thank you. Yes, I really apologize for these technical problems, but okay, the technicians here at the court tried to settle it, and it's settled now. I'm a little bit upset because I'm not really a fan of these technical issues, but I try to do my best. So yes, it's not that simple for a judge to comment his own, the court's own case law, because you bear a risk to say or too much or too little. And of course, you can't reveal every detail you would like to. Professors and others are more free. But let me say just a few words. Thank you, Mr. Botis, for the introduction and for stressing that the Court of Justice of the European Union has a special role, yes, in interpreting the EU legislation concerning, in this case, geographical indications. It's not just the EU legislation which is applicable, as you all know. The protection of intellectual property and especially trademarks and geographical indications, yes, they are regulated by EU regulations and directives, but of course, the EU legislator is not quite free. It's not independent. It must respect also the international surrounding. We are not closed in the European Union. And as you know, there are a lot of international conventions, treaties, agreements concerning intellectual property that is to be taken into account when legislating in Europe. And it, especially as to geographical indications, we had a dispute before the World Trade Organization concerning the former EU legislation on geographical indications. The United States of America and Australia complained against the European Union, and the dispute resolution board of the World Trade Organization, it's 2005, I suppose, yes, ruled that the then European Union legislation was not in conformity with the TRIPS agreement, with the WTO rules. So the EU had to change its regulation. The consequence was the regulation of 2006, afterwards replaced by the regulation of 2011. And still, the Court of Justice must take into account, besides the EU law, the international law. In our field, it would be the TRIPS agreement, and also it has a difficult task to draw a line between the applicability of the EU law and the national law. And I'm not going to enumerate a lot of our cases, but I'll start quoting a recent one. It was a case concerning mozzarella di bufala, Italian case from 2019. It's quite recent, where there was a problem whether the member state, Italy in this case, could impose to the owners of a geographical indications additional conditions as to national law. And the response of the court was positive, affirmative. So in this case, a combined application of the EU law and of the national law was imposed. But let me enter a little bit in the subject matter of today's session. And Mr. Botis, you just interfere when I'm too long or where I am telling something which everybody knows or nobody cares.
Please go on. Please go on. Thank you.
So there are a lot of challenges in this field. The court dealt with the interpretation of different kinds of infringement of the geographical indications under the Article 13 of the regulation, or the Article 16, which is more or less identical, of the protection of spirit regulation, concerning especially the question of the notion of evocation, which is a very delicate one. I'm referring to the cases of Scotch whiskey and Vinnie Verla, which are very well known. But I will just focus my few words on the problem which was exposed in the bench notes, in the notes for this session, concerning the overlapping of different kinds of legal protection of geographical names. Geographical names, I'm using the expression name and not indication, because geographical indication is a technical expression. They are often used to denominate a product, an article. Firstly, we know the use of geographical names which could be called false geographical indications. I'm referring to two cases of our court, the very well-known windsurfing Chiemsee from 1999, and the more recent one, the Neuschwanstein from 2017 or 18, something like this. And this, I'll say a few words of this, the second one. The case of Neuschwanstein. Neuschwanstein is a very famous German castle, a fairy tale castle, and it was deemed to be protected for souvenirs of any kind. It's a castle in Bavaria. Our court decided, I am not entering into the facts, that it is, of course, a geographical name, Neuschwanstein, but there is no link between the products sold or put into the market and the geographical name. So it is a so-called false geographical indication. But let's turn to more important problems, the overlapping of the trademark protection and the geographical indication protections. And I try to be as short as possible. That's why I'm only referring to one case of our court, which deals with the conflict between a collective trademark and geographical indications. Mr. Botis is very well familiar with this case, because EUIPO was heavily involved in it, it's the case of T-board decision, judgment of our court from the 20th of September 2017. The facts are quite simple. And a company, it was the Delta Lingerie, wanted to applied for the protection of the word Darjeeling for women's underwear. Darjeeling is, as known, a geographical name. It's the name of a city in India and West Bengal, known for its excellent tea. And the producers of this tea, the tea board, with an Indian company or group, opposed to the registration of the word Darjeeling for the women's underwear. The court tried in its judgment to clarify the relationship between the two. I remind you, but you all know it, that the court can deal with the geographical indications and trademarks in two procedural ways, or in a preliminary reference procedure, or concerning an appeal against the judgment of the General Court dealing with an application concerning the decisions of the EUIPO. In this case, it was an appeal case, and the court, I am quoting, and I try to more or less terminate with this, just one constatation, it would be the point 62 of the said judgment, the board. I quote, "It suffices in that regard to note that such geographical indications, on the one hand, and EU collective marks consisting of signs or indications which may serve in trade to design the geographical origin of goods and services, on the other hand, are signs which are governed by distinct legal regimes and pursue different aims. Thus, whereas the EU trademark is in accordance with Article 4 of the Regulation number 207/2009, a sign capable of distinguishing the commercial origin of goods or services, a geographical indication is in accordance with Article 55(2) of Regulation 1151/2012, a name that identifies a product originating in a specific geographical area whose quality, reputation, or other characteristic is essentially attributable to its geographical origin, and at least one of the production steps of which take place in a defined geographical area." End of quotation. So the scope of both protections are quite different, but nevertheless, we find in practice that they are mixed, they are overlap, as I told you, which is very well illustrated by the so-called halloumi saga, where the halloumi, the famous Cypriot cheese, was protected by a collective mark, and the court had several occasions to deal with halloumi cheese. I would like to stress that, of course, it's not prohibited to protect a geographical indication by a collective mark. It's expressly provided. And I'll add that the new instrument which was introduced in 2017. The so-called certification trademark expressly excludes the possibility that by this kind of trademark protection, geographical indications could be protected. So that, at least this is clear. And the court is actually faced with several pending cases on geographical indications. I would just mention one. This is the Fromage Morbier case, which is pending. That's why I'm not entering into the legal analysis. The judgment will be pronounced in a month, perhaps. But the facts are extremely interesting. The Fromage Morbier, the producer, demands a protection of its form because this kind of French cheese is known and it's included into protected geographical indication by a dark line around the piece of cheese. So this is a little bit similar to the design protection, and which is not forbidden for a producer. It's not forbidden to choose one or the other protection. It depends, of course, whether the protection is different, and so on and so on and so on. I could continue, but I think my time expired. And of course, for a judge, it's very interesting to listen to others what they mean of our case law, and I am looking forward to hear it.
Thank you extremely much, Judge Ilešič, for your intervention. That was very interesting, and that's precisely what we are going to do now. We are going to give the floor to a more vocal academic who will deal with similar questions. So Dev, again, good morning. I hope that the issue with your presentation has been solved. So what would you say about the possibility of having a multi-layered protection for intellectual property rights whose, let's say, essential functions are not the same, even though they may present some similarities? So we heard this introduction by Judge Ilešič. It's not prohibited in the abstract. On the other hand, this, let's say, parallel protection, we all know it is possible if the specific conditions of protection of its right are, let's say, fulfilled. So the floor is yours, Deb.
Thank you, Dimitris. And my presentation is going to follow on very nicely from what Judge Ilešič has just laid out. So I think it works very well in terms of following on. I'm just reminded of recent decisions by the court in Brompton Bicycle, in Gombok, in sort of cases on copyrights and designs, on trademarks, where the court is exploring this space to avoid monopoly extension through overlaps, but recognize that you can have overlapping rights. And I think it is a difficult sort of territory to navigate. So I'm just going to talk about the trademarks and GIs interface. And it seems like the door may be closing for GIs within the trademark system, which explains the title of my presentation, Separation Anxiety. There we go. So this is the reasons why GIs have historically existed within the trademark system. And the starting answer is for practical reasons. Quite often, there just wasn't a better alternative. So you had GIs as collective marks, because the Paris Convention sets up collective marks for all of its members. And it gave GI right holders a valuable priority date. Then this led to the Madrid system for international registration, where you could get GI protection effectively, some form of GI protection, even in countries like the US or Australia, where you don't have a proper sui generis system, or maybe you only have it for wine. So what do you do about cheeses? So the trademark system allowed some form of protection in sort of third countries. And then even within countries which have sui generis protection, that might be only for certain types of subject matter. So the US has wines, Australia has wines, but not for foodstuffs. And even within the EU, one of the big debates across these 2 days is extending GIs to non-agri subject matter as well, crafts, textiles, things like that. We thought that the EU system was restricted for GIs to just words. So Parma, the word, as opposed to prosciutto di Parma, the word, as opposed to the crown or the logo. But the evocation protection now is very broad. So that problem may have been taken care of. And as we heard in one of the previous panels in the previous session, which I was attending, the domain name system struggles to recognize GIs as a different form of rights. So for many historic or practical reasons, GIs have needed to live within trademark law as well, including as collective marks. And this is an important part of the history. The difficulty, of course, is trademark law is built around individual source indicators. So a sign which points to a single trade source and not to a product shared by a group or not to a group. So it's a question of fit. It's the I versus the we here. And if trademarks are designed to be distinctive and to indicate a specific commercial source, and if collective marks and certification marks are really there to talk about membership or product qualities and often describe those product qualities, then these signs are considered geographically descriptive, or they tell you something about the product. And that seems to be a bad fit because descriptive is not distinctive. And that is our sort of starting point. And it has further implications as well, because if you treat a mark as weakly distinctive, and the judge was speaking about the halloumi case, and I'll come to that, then that turns the dial down on the scope of protection as well. So it weakens protection. So the logic, the classic logic of trademark law seems to be going against the needs of GI producers in this regard. So this is the problem in a nutshell. There's a temptation to treat not just GIs, but even group marks within the trademark system as descriptive. And we'll start to see that tension play out as certification marks enter mainstream EU trademark law, as EUTMs, as collective mark litigation continues to happen. The more descriptive a mark is, the weaker it's considered. And that's part of the problem. Whereas for GIs, the more geographically descriptive the sign is, the better. That's part of the brand appeal. You're celebrating place, you're celebrating geography. And this is the tension at the heart of it. There are 2 understandings of distinctiveness. There is classic source distinctiveness in the trademark sense. So you're pointing to one commercial source versus pointing to a geographical source, which can be shared by a group. And then there's differential distinctiveness, which is, can they really work as brands? And here both individual trademarks and group marks or GIs can work as very valuable brands. Champagne is a very valuable sort of internationally regarded brand, despite not being distinctive in the trademark sense of source distinctiveness. So these are 2 important different understandings of distinctiveness to keep in mind. So what are we seeing in trademark law? Dimitris, that was your sort of question. We're seeing the doors closing, and that's what the sort of the graphic there is supposed to represent. And maybe for good sort of reasons often, but not in all cases. And that's what I'm going to try and talk about in the remaining 5 minutes or so. Individual marks, you can't use individual marks to be GIs because they remain geographically descriptive, and that's one problem. And after the Gozé case, you can't use an individual trademark and the licensing of that mark to achieve a certification function, because then you're not using it in accordance with the essential function of the trademark. There's an oddity about, you would think the best fit for GIs within trademark law would be as certification marks, but that's not allowed at the EUTM level. And I want to come back to that mystery in my last slide. Why it's not allowed is something I'm still not clear about. But you can have national certification marks acknowledging and accepting GIs. So that's one possibility within different national jurisdictions within the EU. And then collective marks have historically been the EUTM or community trademark option for protecting GIs. But that door seems to be closing as well. And I want to talk about why and how that door is closing. So I want to talk about how collective marks have effectively just been hollowed out through a series of decisions which have logic and make sense on their own terms, but are different from the past 20, 25 years of the way in which collective marks have been treated within the trademark system. So the first move that's happened is to acknowledge that collective marks have a different function as opposed to indicating an individual trade source. They talk about membership in a club. You're really talking about association or group or club membership. And I've given an example which might be relevant for all of us. The International Association of Conference Interpreters has its own club or association. And these are the kinds of clubs really that collective marks are supposed to be about. But then the question arises, can the condition for membership in the club be that everybody's satisfied a certain quality requirement? We all belong to the Prosciutto di Parma club because we satisfy the requirements to make Prosciutto di Parma. So therefore you can use collective marks to achieve GI type functions. And there was a provision which suggested that you might treat geographical collective marks more like certification marks rather than normal association of interpreter, normal club marks. And that provision was Article 66.2 of the old CTMR, and you've got Article 74.2 in the new 2017 regulation saying the same thing. And what did that provision do? Well, Article 7.1c, as we will all know, says descriptive signs are bad trademarks. You can't be a trademark if you describe anything about the product, including its geographical origin or its qualities. You need to then prove acquired distinctiveness. We're not going to accept you as a trademark. But Article 66.2 was a derogation to this objection, saying geographical collective marks will always remain geographically descriptive. Prosciutto di Parma will always remain geographically descriptive of the origin of the product, and you'll never lose that through some acquired distinctiveness. So you need to make a special accommodation for such marks and recognize that they indicate geographical origin as well. And so the question that arose was whether this special rule is really a way of saying we recognize that they perform, this group of collective association marks, which are geographical, they perform a GI type function. But that understanding was rejected in the case that the judge was just mentioning in the past few minutes, which is the Darjeeling case. So you see Delta applying for Darjeeling for lingerie, you see the T-board objecting, and part of the difficulty for the T-board is likelihood of confusion is difficult because these are very dissimilar products. Tea is not lingerie, and you would never want the two to be mixed. And also the difficulty with sort of the reputation argument is the T-board has to then prove reputation in the EU, and they haven't actually proved that reputation. Why didn't they just rely on their GI? Because their GI hadn't been registered as yet at that point of time. So they couldn't use their GI as prior rights. So therefore they were using their trademark as prior rights in this case. So what the T-board tried to do was argue that this special rule in Article 66, saying that a certain geographical connotation is fine for geographical collective marks, it's really a proxy for saying this was the historic rule to allow GIs into the trademark system. And so therefore we have to treat the infringement test differently, the likelihood of confusion test differently because of this rule. But this argument was rejected by the EUIPO, by the General Court, and by the Court of Justice as well, saying once you're into the system, we'll treat you like any other trademark, no special treatment, and there isn't going to be likelihood of confusion, not even we won't give you a different likelihood of confusion test. Under the same likelihood of confusion test, these are very dissimilar products, and no consumer is going to be confused. But behind that reasoning was the principle that we're not going to treat geographical collective marks in a sense like certification marks or like GIs within the trademark system. And the judge pointed out the differences between these two marks. So the Advocate General and the Court of Justice list the differences between collective marks and GIs in this decision. The second erosion or hollowing out, if you remember that pumpkin image from my slides a few minutes ago, comes in the Halloumi case. And here the core sort of argument is the suspicion that collective geographical marks are potentially generic or remain geographically descriptive and therefore weak trademarks because they have low distinctiveness. So this is continuing to apply classical trademark thinking to these marks and not making any concessions for them within the trademark system. And you see that in the reasoning of the Advocate General in the Halloumi decision, saying that really these marks have low distinctive character and we can't sort of adequately protect them. The Halloumi Foundation tried to argue a few different arguments. They said, look, we have our foot in the door, we're already registered. And once a mark is registered, there's a presumption, a default presumption that it has a certain minimum degree of distinctiveness. And now you're pushing us back, you're sort of dropping us down, and that's unfair. And they also sort of argue that even weakly distinctive marks can potentially have a strong scope of protection because in some part of the EU, they won't be seen as distinctive. You've got cases like BSH, you've got cases which say that even a mark that isn't very distinctive might nevertheless, for some parts of the EU, continue to have normal distinctiveness protection. But neither of these arguments sort of worked because of that sort of sense that geographical marks are normally bad individual trademarks. So therefore they're weak collective marks. And this is just a mismatch between two systems. And I can see the problems with trying to fit them into collective marks, but then what's the future? And this is my last sort of couple of slides. And no prizes for guessing. The guillotine sort of suggests where I'm going with this. It's bad news for collective marks. And I have sympathy with collective marks, right owners. I think they're being treated quite unfairly, and I'll tell you why. The EUIPO's draft guidelines now suggest that since our idea of collective marks is about associations, we would prefer GIs to come into our doorway as more association type marks. So it's the Rioja example you can see up there. We would prefer those kinds of trademark applications and not just a straight up descriptive Darjeeling kind of application. It's one, not the other. But if the geographical element is always going to be seen as weakly distinctive, always a burden, always some kind of baggage, then what is the value even of a collective association mark? Because the only reason that consumers care about the group of Rioja producers is because they enjoy drinking the wine. They like the product. So it's not very helpful to put the producer group in between as some kind of sort of group of franchisees or licensees or something like that. So that's part of the problem with the solution. So where do we go? This is my last slide. One option might be to return to the idea of treating geographical collective marks more like certification trademarks, because at some point, the EUIPO and the court is going to have to acknowledge that certification trademarks are not like individual trademarks. And I'll give you one example. The Underwriters Laboratory, which certifies product safety, back in 2005 had certified 5 billion products from a range of different companies and undertakings. So certification trademarks talk about the qualities a product has and not about who's made it. These products come from a range of different sources. So it's all about the product and some quality the product itself has. And GIs are more like that, more like certification marks. So do we treat them like certification marks? Or the second question it leads us to is, why were GIs excluded from EU certification marks in the first place? I found no explanation for why this is the case in any public forum anyway. So that's part of the problem. So really, these are some of the solutions towards the end. Maybe think about fitting them back into certification marks. And with that, I'll stop and hand over back to you. Thank you very much.
Thank you very much, Dev. That was very clear. As a takeaway point, I take your last observation. I mean, if the scope of protection is very, very limited, then why register them in the first place? And if finally GIs have more the characteristics of certifying something, why not revive, for instance, let's say, the most natural right in the trademark field that would come closer to the essential function, so create some kind of certification mark protection for GIs. Thank you very much. With our technical problems, we have left very, very little time for taking questions from the audience. I will now ask our attendees to raise their hands if they have questions. Unfortunately, we can take only one or two questions. So please raise your hands if you want to take the floor and ask questions to our panelists. I don't see anybody, but we have received a couple of questions through the chat that go exactly in the direction that we said. They raise this question of different functions. I would like to, since our main subject was the clarity of the law and the need to change the law, and thank you very much both Benjamin and Dev for making suggestions in this regard. I would like to put a question to all three of you. Regardless of the fact that we have different essential functions in trademarks and GIs, when it comes to infringement phenomena like a use or a misuse by a third party, then we get situations where the aspects of this infringement action are very similar like the ones in trademarks. So we need to see the impact on the consumer, we need to see the state of mind they create and all that. So do you believe that it was successful, the fact that to describe more or less similar concepts, like for instance, association, that trademark law uses different terminology from GI law? So is it better to have evocation and not direct association in the GI law? Is this something that complicates the task of the judge and the lawyer and the academic when interpreting these provisions? Or finally, this was a successful idea and we should continue in the same way? So please, a very short comment if you may. Perhaps give first the floor to Judge Ilešič.
Yes, thank you. Yes, the question is indeed a challenging one. We face it often. For example, yes, you didn't mention that also the trademark law speaks about likelihood of confusion. This expression doesn't exist in the geographical indication law. Then the regulations use the word expression misleading or something like this. So I'm not sure that they are identical as to contents. The essential problem of differences in functions of the both institutions should remain intact, I suppose. The trademark law guarantees the knowledge of the market as to the origin, and it's not necessarily the case for the geographical indications. Of course, we should think about unifying the terms where possible, but I'm not sure whether it can be really unified. The examples of the collective marks show it clearly. The collective mark, as Professor just said, cannot fulfill the same aim of protection as the geographical indications do. Thank you.
Thank you very much. That's very clear. Indeed, what you say is absolutely true. When we have to express different concepts, we have no option but to create perhaps terminology for that. On the other hand, we also see that the court itself sometimes, or advocate generals, cannot resist the temptation to use trademark terminology sometimes to refer to things. So use the term similar when they describe comparable goods, or we saw the Advocate General using the word confusion in the context of misuse, in his opinion, in Mauvier. So thank you very much. I think that we just have time to give the floor to the only attendee who has asked for, oh, I see a second one now coming. So the first one was Alberto Ribeiro de Almeida. So if the technicians could please give the floor to our guest, and then tell me if we can go beyond 12:45, that it's the nominal end of the session, to give the floor also to somebody else. So could we please unmute our attendee who wants to speak?
Hello, good morning. Thank you. Thank you, Mr. Dimitris. It's a pleasure to see you again. And all the speakers, my congratulations to all of them for the wonderful communications. I'd like just to raise two questions. One for Mr. Benjamin Fontaine. At least I'm concerning about the last, I think it was the last slide where you made a proposal for the future. When you refer to dilution, I'm sure that you include dilution by blurring and dilution by tarnishment. That is also something that GIs are worried about. And concerning the communication made by Mr. Dev Gangjee, I'd like just to ask two points. According to what everything you have said, this means that geographical terms that can be registered as trademarks in certain cases, as you know, can never get the distinctive power to be registered as a trademark or not. Because if geographical terms, as we have several examples in the marketplace, that there are trademarks composed exclusively by geographical terms and they are trademarks, why shouldn't GIs also be protected as trademarks? I agree with many of your points, but it's just a question on this matter. And finally, concerning collective marks, I think we have another problem when GIs try to be protected as collective marks, because collective marks are a club, a private club, only for those that are members, and GIs must be opened to new members. And so we could have here a problem if we protect a GI as a collective mark, because it could be closed to some members, and well, GI must be open to new producers that comply with the specifications. Thank you very much once again, and it was a pleasure to participate in this forum. Thank you.
Thank you very much. We thank you very much for your comments or already very valid points. We take note. I'm sure that Benjamin has not forgotten the danger of dilution of GIs when he spoke about fair reputation. Indeed, thank you very much. I see also that Mr. Christoph Zimmer would like to take the floor. If you could also please give the floor to Mr. Zimmer.
So thank you very much. My name is Christoph Zimmer, and I'm from Germany.
Sorry, we cannot hear you. Yes, could you please try to unmute yourself again, because there was some problem, the sound was cut. You're still muted. Okay, I think that we have a problem hearing Mr. Zimmer, and unfortunately our time has also run out. So we need to go back to the plenary room for the concluding remarks. So here is where I will thank again very much our speakers for the very useful exchange. Thank again Judge Marko Ilešič for having the kindness to be with us today. Benjamin, Dev, thank you very much. And I think that the points that were made were very clear. And let's go back now to the plenary session. So